Afternoon, everyone. My name's Marcus Wilkerson, as you've heard, and I represent Terrell Thomas, the defendant in this case. I'm going to echo the sentiments of the court, as well as State's Attorney, Mr. Ham. Thank you all for being here. This is the due process that our Constitution guarantees, right? The ability to confront an accuser, the ability to question a witness about their version of events, the ability to sit facts out in front of jurors and have a juror or a jury of our peers make a determination as to whether or not we are, guilty or not guilty. I have COPD, y'all. So if I lose my breath or start to feel shaky or something, I'm okay. I'll make sure I bring my inhaler. So if I have to take a pause for a minute to take a breath, that's why. I also have my mouth gets really dry because of various medication. So just full of all kinds of wonderful things. So you'll probably see me eating candies or drinking a lot of tea or soda or whatever I can get my hands on at the time during this. If you're lucky enough to stay with us, and I know all of you just absolutely want to be the ones to be here for the rest of the week. Before I get into my questions, there are just a couple that I did want to ask y'all. In discussions about the witnesses and the testimony in this case, we believe that the case might conclude by the end of the day Wednesday, maybe go into Thursday. Does anybody have any kind of appointment or anything like that that is very important, like a doctor's appointment, surgery, something like that can't be rescheduled, that you have to attend during that time frame? Yes, ma'am. Number 4.
We had that and the meeting Thursday was
I'm very sorry for your loss, especially, there's never a good time, but holidays. So thank you for sharing that. Yes, sir. Number 16. And is she going to be anesthetized, or does she have to have a driver? Anybody else? 20?
Yeah.
Yes, ma'am.
I can't hear.
So, caretaker, so I did a presentation, in there.
Okay, nephew, you said who he stays with you and he has chemotherapy and he has chemo appointments this week?
Yeah.
He has them every week right now, and you're the person who he relies on to get him back and forth?
This is Lydia Stop. Coming up.
Thank you for sharing that. Anybody else going down sorry y'all, 32? I'm sorry I couldn't. And I assume, since you're bringing it up, that you're the only one available to take her? Well, I can't guarantee you those things will exclude you. We certainly will take it into account and talk to you further if necessary. So, thank y'all. So, as you have been told already, right, this is a process of really deselection rather than selection. And so what that means is we have a very limited amount of time that we get to talk to you and try and learn a little bit about you in this very limited amount of time. And sometimes in that process, we may ask questions that don't necessarily make sense to you. Sometimes we may make jokes, even though in a situation that's being tried in this court is very serious, as all felonies are, and often have victims. And that doesn't mean that we're not taking this seriously or that it's not a serious offense, but simply that we try to bring a little bit of levity into any situation that we can. Just because without a little relief, all of this stuff just weighs you down and weighs you down. On my phone. My breath did anyway. A little bit that I've got. All right. So, anybody? Well, anybody? I think Judge went over the reasons or the qualifications. Not sure he went over all of the excuses. Does anybody, let me just ask it this way right now. Does anybody have any other reason, aside from those who have indicated already that they want to talk to us, that they would not be able to sit on this jury or think they might have a reason they would not be able to sit on this jury? Mr. Is it Waltrip? All right, we've got you down to talk to you already, so we'll take care of that afterward. Oh, all right. So one of the reasons that I come up here and tell you a little bit about myself personally when you're going, I'm not here to hear about you. It's not easy, right? You've already heard some discussion about what it's like to sit in judgment of another person. It's an unenviable job, and it takes courage. It takes steadfast dedication. It takes a will to actually serve your community at large. And so, as I indicated earlier, thank y'all for being here. Without you, we wouldn't have the justice system we do have. So, Mr. Ham touched on an issue earlier. Obviously, it doesn't happen as much in cases like this that don't often go to trial. He used an example of murder or in cases of some types of abuse. This issue comes up a lot. But not all cases are right for all jurors, right? What does that mean? Well, if you were at your house last night and your car got stolen, and then you come in to sit for a jury today, and the case is about car theft, you may not be the best person for that jury, right? So I'm gonna skip around in my slides here and just ask. So, in terms of the golden rule question, so to speak, is there any reason that you think you might not make a good candidate for a jury of charges of this nature? Yes, ma'am. What's your name?
Sharon.
Sharon. And your number 29? Are you comfortable sharing it, or do you want to? Okay. I'll mark you down to talk to you after a while. Similarly, the law requires, and this is just in passing, right? Not just that there not be any impropriety, but that we avoid the appearance of any impropriety. So if y'all see me out in the hallway or see other counsel out in the hallway, and we just kind of duck our head and walk by you, it's really, we don't want to ignore you at all, I promise. It's just we're trying to prevent any of that appearance of impropriety. So, there may be occasions where you get stuck on an elevator or something like that, and a quick greeting is exchanged. But if we go the other way or wait to get on another elevator or something like that, No, it's not because of you. It's just because that's what the law requires of us. So, as you heard discussed earlier, an indictment is not evidence of guilt. Um, so there's a place later in my questioning that I go back to the burdens of proof, but to just kind of walk through them real briefly, right? You've got your reasonable suspicion, which is what is required to pull you over. Some reasonable suspicion, some offense might have occurred. It's what's required to stop you on a sidewalk and pat you down. Some reasonable suspicion that can be articulated that there might be some criminal element to your behavior. Now, the next level up is probable cause. And that is what brings us here today, right? Probable cause is what is needed to secure a warrant. It's what is needed to arrest somebody. It's the same level of or same burden of proof as an indictment, right? They're all the same level of proof. And so it's important to understand that in part so that you recognize just how low that kind of standard is, right? I mean, a probable cause, when you hear probable cause, you think, does that mean probably committed something? No, not at all. Not at all. And words have power, right? Words define how we think, how we process information. So if you are considering a probable cause, then and you think probably committed an offense, that's not it at all. Preponderance of the evidence standard, that's that 50.0001 percentage, right? And that is that's where, okay, yeah, it's a little bit more obvious that this person did something as opposed to the other, right? And so that is the first standard of proof in terms of civil cases, right? The next standard of proof is called clear and convincing evidence. And clear and convincing evidence is the standard of proof the state would have to meet in order to terminate your parental rights, right? So I often ask, what do you think, for those of you who are parents or grandparents, what do you think the state, what burden do you think the state should have to meet if they were going to say, yeah, you no longer have parental rights to your kid? It would be by clear and convincing evidence that some act of abuse or neglect has occurred. And generally, there's an opportunity or a program to try and improve yourself right during a period that a case is pending. So, all right. So, raise y'all's hands if you're married. Right? All right. Most of you. So, when we talk about the presumption of innocence, all of those of you who raised your hands, if your husband, for those of you who are ladies, if your husband came home with this on his collar, how many people think that would turn into a big argument? Yeah, a few people are really, yeah, that's going to be an argument, right? Well, in law, right, the presumption of innocence says that this isn't evidence of wrongdoing. It could be, but it needs further inquiry, right? What if your husband met his sister or his niece or a former friend from childhood? They ran into each other at a cafe and had lunch together. And when they hugged, lipstick got on the collar. You know, there are a lot of other explanations for things that, while our mind typically goes directly to, oh, this is because of that, right? You have to look at things, you have to question things, you have to pay attention to the details. Judge already talked about this. He does a great job of going through kind of a primer on a presumption of innocence and burden of proof. So in terms of demonstrating that an offense has occurred, there are multiple pieces of evidence, right? And evidence consists of testimony. It consists maybe of documents or photographs or recordings that have been proven up in accordance with the rules of evidence, the burden we have to carry to be able to let you hear or see something, and you still have to examine it, right? Anybody want to take a stab at what this says? All right, so a few people, nobody raised their hands, but a few people said it out loud, right? Jumping to conclusions. This is what happens when you jump to conclusions, right? So this is really just a little exercise to say, look, it is understandable to want to take what you might think is obvious and translate that into actuality, right? That it become real at that point. Oftentimes in cases, prosecutors will show you a picture of a puzzle, right? And say, okay, you don't have all the pictures of this puzzle, but you have enough to demonstrate what the picture on the puzzle is, right? Like if it's a dog and a cat together, you don't have to have all the pieces to understand that. Anybody want to take a shot at what this is? Nobody feeling interactive? Juror number 2.
Yeah.
Done? All right. Okay. So, what about though? Well, okay. Finally started working. What about now? Right? Right. So, one piece of the puzzle, right? One piece of the puzzle changed our understanding of the picture, right? And that's why, look, it's never possible to know something beyond all doubt, right? Unless you were there and experienced it or witnessed it, but then you wouldn't be sitting there, you'd be sitting up here, right? You have to be careful about the pieces that you assume fall into place. So when I talk to potential juries, I like to point out that it is not, we don't necessarily have to see different things entirely, right? We can all look at one thing and sometimes see things differently with a different perspective. Juror number 17. What do you see when you look at this picture? Um, okay, so let's do, do you see a woman in that photograph? Yeah? All right. How about now? Anybody see something different when it's highlighted like that? I mean, some people see an elderly woman, some people see a younger woman looking away, maybe with some sort of fur on. This is the same picture, but from different perspectives. And the state, during its presentation, talked a lot about mental health and talked about the insanity defense, which is not a defense here. Talked about issues of mental health coming in potentially in punishment. And that is where the focus on any type of mitigating circumstances might be, right? But when you are evaluating whether or not someone committed a criminal act, when there is a what we call mens rea, right, or an intent element, and in this case, it's intentionally or knowingly, right, meaning the defendant had to do whatever the state is accusing the defendant of doing, either with intent to cause that result or knowing that that result would occur. So, I'm not going to ask you to answer out loud, but can some of y'all see where one person might come away with a different perspective than another as to whether or not somebody knew what they were doing at any given time? Are there things that would impact that? Now, the court will instruct you on the law after all of the evidence is presented. I don't want you to read anything into some of the questions I'm asking or statements I'm making. You will get what you need to adjudicate this case if you serve on this jury. You will get that from the court after all the evidence is presented. How many people think that somebody against whom an offense has committed? Actually, let me do it this way. Let me just go down the row by row. And this is a simple yes or no answer, okay? Should a person who is a perceived victim of an offense have a say on whether or not those charges proceed? In other words, should somebody who is victimized be able to determine whether or not the person who victimized them is prosecuted? I'm going to start with juror number 1. Yes. 2, 3, 4, 5, 6, 7, 8. Sorry. 8, 9, 10, 11. No. 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22,
Yes.
23, 24, 25, 26,
No.
27, 28, 29,
Yes.
30, 31, 32, 33, 34, 35,
Oh.
36,
Yeah.
37. I'm sorry, thank you. 38,
No.
39, 40,
No.
41, 42, 43, 44,
Yes.
45, 46, 47.
46.
Yeah, they're not there, so that's why I skipped over. 47, 48, 49, 50, 51, 52, 53,
Yeah.
54. Oh, not there. Appreciate it. 55, 56, 57, 58.
Yes.
So that's a pretty broad spectrum of yeses and nos. And there are ample reasons, right, to go one way or the other. For instance, is it possible that somebody who has been a victim of a criminal offense is scared to prosecute that offense? Is it possible that they are caught up in some sort of codependent, toxic type of battery issue where it's something that's recurring over and over and over, right? Is it something where the person who was victimized, knows the person who allegedly victimized them the best, and knows if a certain behavior was a one-off or if it was the kind of behavior that you could expect for this individual, right? There are questions and reasons on both sides. And so these questions, right, there are no wrong answers to them. It's just, how do you feel about certain things? Oh. All right, I told y'all we would circle back a little bit to the burdens of proof. This is just another visualization of the same burdens or standards that we discussed a little bit earlier. The next one is my favorite, and it's my favorite because most of us, unless you're an attorney, don't speak in terms of preponderance of the evidence or beyond a reasonable doubt every day, right? That's just not how we talk to others in our life. We're often much more colloquial. Sorry. We're often much more colloquial in our conversation. And the reason that I like this particular model is because all of the colloquialisms, right, that we use in our everyday communication with each other are all set forth on a scale that I think makes reasonable doubt something that is more understandable. Several people have said, can't tell you what it is. Most people know it when they see it. Sometimes it's not clear. Anybody believe that there are people who, or does anybody dispute, rather, let me phrase it that way. Does anybody dispute that there are people, for better or worse, that are tried and acquitted and yet committed the offense? Everybody acknowledge that that happens. Yeah. By the same token, can everybody acknowledge, especially years ago, but even through present, that there are times when somebody who is not guilty of an offense has been convicted of an offense, right? And there are a plethora of reasons for this, right? A whole spectrum of them. But what I don't believe is that every one of these cases where somebody was convicted and they might be innocent, that all those juries were just out to imprison somebody, facts be damned. Also, though, I don't think that the juries who have acquitted somebody who actually committed an offense just set out to say, oh, well, this law doesn't need to be enforced or something of that nature, right? The burden wasn't met for that particular jury at that particular time. With the advent of technology, DNA evidence especially, we've discovered a number of people who were convicted years ago, and then that DNA evidence in turn exonerates them. So all of that is to ask a question that is very uncomfortable to answer and difficult to answer. So I'm sorry for your seating arrangement because usually people are kind of leery to start down a discussion of this nature. So this is what I want to do. I've got a statement up right now. It is better a guilty person go free than an innocent person be imprisoned. And I want to ask y'all how you feel about that. Again, there is no wrong answer. Some people would prefer people be locked up rather than potentially letting somebody out who committed an offense, right? And some people would prefer that if it came down to it, that rather than convicting somebody who was not guilty, they would err more on the side of caution. It's not a comfortable question. None of us want to believe that we would make that mistake, right? Because this is difficult to sit in judgment of one another. So, with that, I want to go down the row and
Just a second. Can you explain what you're trying to get at in this voir dire? You're asking for people to hypothesize on something that no juror ever is in a position to know. That is, whether someone is guilty or innocent. It's based upon the evidence presented, not clairvoyance.
yet I'm asking for
And
a
what
philosophical.
point does it make? Because they will take an oath to see that justice is done based upon the law I give to them and the evidence presented. What part does that play in that?
That's a
What part?
philosophical.
A philosophical?
Yes, it's a
You mean like
philosophical.
how high is the sky? I mean, where it's boundaries. The point is you don't know ahead of time. It's
No.
for the jury to make a decision based upon the law and the evidence. What is the relevance for that question, other than hypothetical? Yeah, if you articulate it, I'll let you go, but what is the point? It's all based upon the oath they take and the evidence presented. That's what this is all about.
Indeed.
Better a guilty person go free than an innocent person be in prison. We're just it's pure speculation. It has nothing to do with their oath that they will take, nor the law that's going to be given to them. Or does it?
In my
Can you
opinion,
articulate a reason?
yes, because it weighs
What's in
on.
the law and what's in the oath that they take that is relevant to that?
It's a burden of proof issue.
The burden
But-
of proof is beyond a reasonable doubt. They know that.
And so, is the suggestion that those who have been previously convicted and are later exonerated, that burden was still carried and those, I mean, the exoneration is wrong, or is it?
That's why we invented appeal process to try to fix errors. But you can't second guess what jury is done except on appeal. That's the fallback position the law has on it. And to make them, to apply to this case and these facts and this law, the fact that someone may have been exonerated later is inappropriate of that. It doesn't have anything to do with that. It's made up by human beings. It's an imperfect system. We do the best we can. That's why out of the 200 plus countries, we are the far leading one in jurisprudence.
Well,
All right, let's move forward.
all right. So one of the questions or one of the discussions that were had going into this, you were presented with the worst case scenario, right? In the worst case scenario, are you comfortable with the minimum of 25 and a maximum of life? So, moving past the worst case scenario, because there are different ranges of punishment for various scenarios. Moving past that, as discussed, as has been indicted, the punishment range, right, is 5 to 99 to life. Is there anybody who feels like they cannot consider the minimum in a case of aggravated kidnapping? So let's go a step further. If convicted, then in punishment, it is shown that a person who committed the offense of aggravated kidnapping voluntarily released those who were unlawfully confined in a safe space, that punishment range then steps down to between 2 years and 20 years. Could everybody consider, if that was proven, the minimum of 2 years and a maximum of 20? Anybody on the first row have an issue with that? No? Second row? Everybody comfortable with that? Both ends, maximum and minimum?
That's not the test, whether they're comfortable. It's.
Can you
they
consider-
follow the- Let me speak. You can't both speak over the next one speak, you don't stop, you know. It's not the test whether they're comfortable or not. Can you follow the law? That's the test. Whether you're comfortable or not. Is the test. Can you follow the law? This. Nobody knows better than this court. I don't like the death penalty. But I asked the Jamesburg killers to be executed. You've got to consider the full range with an open, fair mind from lowest to highest and fit within that range what you think is right based upon the law given to you and the evidence presented. And judging other people, I can't find out where people are not discomfortable with that because it's a fellow human being. Go ahead, ask your question.
Thank you. Third row, can everybody consider a minimum of 2 years up to, depending on where we end up to all the way to life? Everybody comfortable with that? Oh, I'm sorry. Can everybody consider those maximums and minimums? Fourth row, everybody can consider those maximums and minimums? I'm just gonna pick on you because this may be the only time or the only only opportunity I have to ask you. Are you related to Judge Crum?
I am, so I used to, on a federal state map, you can comment on what punishment would be. In terms of time.
So sentencing in the federal system is very, very different from sentencing in a state system, right? In state, laws provide for a specific range of punishment. There is something called the United States Sentencing Guidelines in federal court, and those guidelines attempt to account for a plethora of different circumstances. And what happens is essentially a value is calculated, right? And then you've got whatever that value is, you're within a certain level and category in a federal system, as opposed to the state system, where obviously if a jury is considering punishment, we try and present as much as we can about those circumstances. Sentencing in the federal system is done by the judge, and the factors that I was kind of alluding to, those are tallied up by the probation department, basically, and you have an opportunity to object to any potential issues that you see in that calculation. And then you can ask a judge for an upward or downward departure, depending on which side you come down on. And the judge can decide to grant that upward or downward departure or deny that request and sentence specifically within those guidelines. Plea bargaining also in the federal system is very different. And so it would certainly, I would love to go into a discussion of all that with y'all,
Not today.
but not today. But thank you for that. So those of you, juror number 36, did you have any relatives who were in law enforcement? Are you married? You are currently employed. You addressed that issue. Juror number 37, you indicated, Montero. My apologies. Thank you. I tell you what, let's do juror number 30. So, you indicate, ma'am, that your husband and nephews, are law enforcement officers. The allegations in this case, as you heard articulated by the state's attorney, involve a standoff between police and the defendant. Would that relationship whereby your husband, or nephews are law enforcement, would that prejudice you in either way toward the defendant?
I don't think all of them have incidences, but even in the hostage situation.
You said you don't think so, and I can very much appreciate that. Obviously, what we don't want, right, is to get to a position where we've got a jury seated, and all of a sudden it's a situation where, oh, the situation here, I feel like endangered law enforcement to a significant degree, and because I'm so close to a law enforcement officer, I'm going to be biased against the defendant in the case. And I apologize for trying to drill you down, but under those circumstances, would you be able to set aside those relationships and be unbiased? You think so? Okay. Let me, there are a few of you out there, some with sons and daughters, sons-in-laws, cousins who are in law enforcement officers, or who are in law enforcement rather. I'm gonna ask you in general the same question. Is there anything about that relationship for those of you who have those relatives in law enforcement that would cause you to be prejudiced or biased against the defendant or against the police? Yes, sir. I'm sorry. What's your number? 50? And just so I understand, are you suggesting that you, I believe, have a son who is in Port Arthur Police Department, and was at least at one time Jefferson County Sheriff's Department, and then a daughter who's with Port Neches PD? Is that correct? And so you raised your hand. Am I to take it that because of the closeness of those relationships, you might be biased against the defendant since there was allegations of a standoff in this case?
In that case. Might be a little biased, to be honest.
You'd be biased? Thank you for that. It's difficult sometimes for us to admit when we might have a bias or prejudice because all of us want to believe that we can look past our own associations and preconceived notions. But those of the people who are very self-aware are able to look at themselves in an introspective manner and say, okay, yeah, I may, this may cause me bias or prejudice. So I thank you for being open about that. Anyone else in a situation that's similar where they might be biased against the defendant or against law enforcement? Yes, ma'am.
Relationship, but I'm going to have him speak to y'all privately.
Yes. What's the number?
Number 12.
I think I should be added to that list too.
What's your number, ma'am?
5.
25? All right, so circling back to yes, sir.
My bad. My son does work in the Jefferson County Prosecutor's Office.
Okay. Your number 40 and that relationship and that closeness with a family member in the district attorney's office, would you be able to set that aside?
You need to know it.
Well, and I very much appreciate you making us aware. I do. In fact, I did not, well, the question was specifically about law enforcement, though, and a district attorney is not necessarily considered a law enforcement officer. So I understand why you didn't make any indication on your questionnaire. But thank you for bringing that to our attention. I saw another hand come up. Yes, ma'am. You did note your brother was a court officer. Similar question, is there anything about that relationship that might cause you bias or prejudice against the defendant?
No, sir.
Okay. And Mr. Ham went through a list of people asking you if you knew any of them. I want to circle back to that. Anybody familiar with or know Tanya Buentello? Just asking because Miss Gillen recently changed her name, at least that's my understanding, due to a marriage. So that's why I was asking you about a different name. So that pretty much wraps up my presentation. Just very briefly, again, those of all of you who showed up, man, thank you, because this is justice at work, and it's messy and it's difficult, but without you, it can't be done.
George, please. Visit me. Say it again. What else?
16 to 17.
What do you say?
Fine.
That chance.
I know that she's got it. She's got it. It's a short.
Okay. Yes.
30.
Yes. What else? Okay, but the ones who are absent, verse 6, 10, 37, 46, and 54. That's it. That's it. Okay, here's what we're gonna do. Ladies and gentlemen, I'm gonna ask you to relax, stretch your legs, and the lawyers are gonna make their strikes, and we'll need a little bit of time, and it may be 30 minutes, hopefully, give or take that. But relax, stretch your legs, and report back outside in about 30, and we'll keep you updated on this, but we're gonna try to get you out of here. Hold on. We need to speak to the following people.
Hang on.
There's several folks we're gonna have to speak to.
Hold on.
Get them back. Come on. Beginning with number 4. Yes, ma'am. Ms. Quarter, if you can stay behind and we'll talk to you first. Number 9, Eva Eaglin. Number 9, there you go. Yeah. 12, Tisha Rich, and 13, Miss Jackson, and 16, David
Howland, and 17, Sonia Elefano. And there we go. The 20 is Carla Sierra, and 23, Janet Cook. And it'll be in this order, and you can take it one at a time and just stand out in kind of a queue, and we'll bring you in quickly. 25, Naomi Torres. 29, Sharon Carrington. 30, Jane Hollier. 32, Brittany Henderson. 50, Rudy Orta. And 56, Clifton Baltrow. Okay, in that order. Thank you, everybody else. You can be excused, relax, stretch your legs. This quarter will. Oh, John. John.
It tries to set it up there. You might do the person. Go ahead.